Good day, ladies and gentlemen. Welcome back to another What If video. In today's video, I will be discussing what if an employee works beyond their retirement age without a new agreement or contract. Now, in a typical scenario, an employer has a retirement age of, let's say, 65. And in this scenario, when reaching the retirement age, the employee is simply allowed to continue working without entering into a new contract or agreement. Now, in such a case, the question is whether the employer can retire the employee at any time after reaching the retirement age, or does the fact that the employer did not retire the employee when reaching 65 result in an amendment to the retirement age? Now, to answer this question, let's just start with the relevant provisions in the Labour Relations Act. Section 187(1) or subsection 1 provides that the dismissal is automatically unfair if the employer, in dismissing the employee unfairly, discriminated against an employee on the grounds of age. However, notwithstanding this protection, Section 187(1)(f) provides that the dismissal based on age is fair if the employee has reached the normal or agreed retirement age. So a dismissal based on age would not be automatically unfair where the employee has reached their normal or agreed retirement age. Now, agreed retirement age is typically the age that the parties mutually agree upon, either in an employment contract or in any subsequent agreement. Normal retirement date is the date identified as the usual retirement age stipulated in, for example, a pension or provident fund scheme. And the difference there is quite important. Now, the case I want to deal with is the solidarity on behalf of Gerhardus Viljoen and 5 others. And let's start with the facts of the matter. 5 employees had been allowed to continue working past their retirement age, agreed or normal retirement age of 60. And this retirement age was specified not only in the pension fund rules, but also in their contracts of employment. The conditions of service, so the employee handbook, for example, provided that subject to consent of the employer, a member who has reached his normal retirement age of 60 may remain in service and retire at the age of 67. So in terms of the conditions of service, employees can continue working until the age of 67, subject to consent. So the employer must consent thereto. Now, in this case, the employees argued that by allowing them to work beyond their retirement age, the employer had tacitly agreed to the new retirement age being 67 years. Now, the court, in looking at this, noted that to determine whether consent was given by the employer, we need to look at the meaning of the term consent, and specifically whether it should be in writing or verbal, and whether it should be given before or after the age of 60. Now, the court noted that the answer of this question was found or to be found in the special rules of the pension fund, which states that a member must retire from service on reaching the normal retirement date, which is 60 in this case, unless his employer agrees in writing to his remaining in service after that date. In this case, the employees argued that this agreement in writing could be imputed from the written communication from the employer issued after they reached a normal retirement age, which communication confirmed the decision of the board of directors to approve their annual salary increases. On the other hand, the employer argued that the duration of the contracts of employment could not be lawfully extended beyond their termination dates in the absence of a written amendment to their contracts of employment. As the contracts of employment stated, there's a specific clause to say there must be a written amendment. The court concluded on these issues that the applicants, the employees' argument that the salary adjustment letters constitute written consent is a bit of a stretch as its contents are unambiguous. The court said that the employer is correct in its contention that any amendment to terms and conditions of employment of the employees had to be in writing as required by their contracts of employment. The court noted that the consequence of allowing employees to work beyond agreed or normal retirement age was well articulated by our Labour Court. The court referred to specifically the Bank versus Finkelstein matter, where the Labour Court held where an employee works beyond an agreed or normal retirement age, The harsh reality is that such an employee is in effect working on borrowed time. The employer, this is what the court in the Finkelstein matter said, the employer, unless it can be proven that the employer specifically waived its right to apply the retirement age, would remain entitled to at any point after the employee had attained the normal or agreed retirement age to place the employee on retirement. So in the solidarity matter, in considering this case, the court then concluded that there was no merit in the employee's argument that the employer's failure to engage the employees with a view to reach an agreement on a new retirement age amounted to a unilateral determination of a new retirement date, or that in the circumstances the employer tacitly agreed to allow the applicant employees to remain in employment until the age of 67 years. The court held that if there's no agreement on the retirement date once the employee reaches the normal retirement age, then the employer is entitled to enforce the normal retirement age any time thereafter. So ladies and gentlemen, in conclusion, the court then concluded to say that the normal retirement age of 60 years remained uninterrupted and binding, and the employer could avail itself of the protection prescribed in Section 187 that we refer to from the date the employees reach the normal retirement age and at any time thereafter. So ladies and gentlemen, that then brings us to the end of this video. I hope you found it interesting and useful. Should you have any questions on the topic of retirement, please do not hesitate to contact us. As I have said before, if there's any topics or cases that you want me to look at and unpack in these videos, you are welcome to contact us or leave us a like or a comment in the comment sections. Thank you very much for watching. I'll see you in 2 weeks' time. Bye-bye.